welcome everyone to the podcast today. As mentioned in the previous episode, today we will continue to discuss the important and necessary issue for foreign employees who are granted a work permit in Vietnam. In this episode, we will continue to learn more about the rights and obligations of foreign employees when working in Vietnam, how to apply for a visa for them and for their family, and whether there are any restrictions on occupation for foreign employees. As in the previous episode, the guest who will discuss the topic today is Mr. Tran Ngoc Thuyet, a senior lawyer at BLawyers Vietnam. Welcome to the podcast, Mr. Thuyet.
A greeting to all listeners of the podcast, and hello, Ms. Thuy Linh. I am Tran Ngoc Thuyet, a senior partner at the law firm BLawyers Vietnam. I am happy to be able to continue discussing this topic related to the foreign employee in Vietnam.
Hi, Mr. Thuyet. Many foreign employees want to know about their obligation to participate in social insurance and their tax obligation during their stay in Vietnam. Could you please explain this issue to our listeners?
Thank you for your question. The obligation to participate in the social insurance and the tax obligation by foreigner employee is regulated as follows. The first, foreign employees are obliged to participate in the social insurance and the health insurance under the Vietnamese law on labor. The insurance contribution for foreign employees are as follows. Foreign employees working in Vietnam are subject to the compulsory social insurance when they have a work permit or professional certificate or practicing license issued by a competent authority in Vietnam and have an indefinite employment contract or a fixed-term employment contract of at least 1 year with an employer in Vietnam. Accordingly, foreign employees working in Vietnam who are subject to the compulsory sun-based as a person of their monthly salary used to calculate the social insurance, contribute to the pension and the death insurance fund on a monthly basis. Regarding the employer, the proportion of social insurance payment for foreign employees is as follows. 3% into the sickness and maternity fund, 0.5% into the fund on labor accident insurance and occupational disease, and 14% into the pension and the death insurance fund. Regarding the health insurance, foreign employees shall pay 4.5% of their monthly salary into health insurance each month, with the employer paying 3% and the employee paying 1.5%. The monthly salary used to calculate health insurance contribution cannot exceed 20 times the minimum salary set by the government, which can be set at different times. Regarding unemployed insurance, foreign employees are currently not subject to the unemployment insurance contribution under provision of the law on employment 2013. The next, foreign employees are required to pay personal income tax when working in Vietnam, especially as follows. For resident individuals who are the individual present in Vietnam for 183 days or more in a calendar year or the 12 consecutive months from the first day of presence in Vietnam, the BIT levies at the progressive rate. For example, a monthly tax income from 0 to 5 million Vietnamese dong is subject to a tax rate 5%, from 5 million to the 10 million Vietnam dong to the tax rate of the 10%, from 10 million to the 18 million Vietnam dong to the tax rate of the 15%, and from the 18 million to 32 million Vietnam dong to the tax rate of 20%. For non-resident individuals who do not meet the condition of the resident individual as mentioned above, The PIT for income from the salary of non-resident individual is determined by the taxable income from salary by a tax rate 20%.
During the period that foreign employees have been granted work permits to work in Vietnam, visa can be granted to their family to enter Vietnam to visit, live, and study.
Under the law, the visa issued to foreign employees in Vietnam who are confirmed to be not subject to a work permit except in case where International Treaty to which Vietnam is a member have different regulation is a type of the LD1 visa. And the visa issued to foreign employees in Vietnam who are subject to work permit is a type of the LD2 visa. Foreigner employee in Vietnam may be granted to work visa with the code LD1 or LD2 as mentioned above, and may apply for the temporary resident permit with the same type. Example, type of the LD1 or LD2 visa. The validity of LD1 or LD2 visa is not more than 2 years. And the validity of the temporary resident permit with the code LD1 or LD2 is not more than 2 years. According to regulation, foreigners who are a spouse or are the children under the year of the 18 of foreigner who has been granted a type of LD1 and LD2 visa, or are the foreigner who are the parent, spouse, or children of a Vietnamese citizen are granted a type of the TT visa. Accordingly, the validity of a type of the TT visa is not more than 12 months. In addition, foreigners who enter Vietnam with a type of the TT visa will be subject to the case eligible for the temporary resident permit with corresponding type of the TT visa.
Can you please discuss the rights and obligations of foreign employees during their time of work in Vietnam? Do foreign employees have the obligation to comply with and ensure the implementation of regulations and collective labor agreements of the employer in Vietnam?
Under the law of labor, a foreign employee who has been granted a work permit in Vietnam have the responsibility and obligation to comply with the collective labor agreement of the employer in Vietnam, and are also protected by Vietnamese law except in international treaty in which the Socialist Republic of Vietnam is a party have a different regulation. Accordingly, foreign employees must comply with the following obligations as follows. The first, implementing the labor contract, the collective labor agreement, and other legitimate agreements. Second, complying with the employer labor discipline, labor regulation, management, execution, and observation. And the third, implementing the provision of the law on labor, employment, occupation, education, social insurance, health insurance, unemployment insurance, and the labor safety and hiring. Similar to Vietnamese employees, foreign employees who commit disciplinary violation of the employer labor regulation will be subject to disciplinary violation in accordance with the regulation of Vietnam labor law. Accordingly, the procedure for disciplinary violation against foreign employees generally include the following steps. Step 1. When detecting a foreign employee who has violated labor discipline at the time of when violation occurs, the employer shall make a violation minute towards such an employee. Step 2. After making the minute, the employer shall notify the employee representative organization in the establishment where the employee is a member. Step 3. If the employer detects behavior of a labor discipline violation after the time the violation occurs, The employer will collect on evidence to prove the employee fault. If the violation case has several complicated details and the employee continuing to work will lead to the difficulty for the verification, the employer has the right to temporarily suspend the employee assignment. Step 4. At least 5 days working before the day of labor disciplinary meeting, the employer shall notify the labor disciplinary meeting party of the violation. Step 5. When receiving the employer notification, the party mentioned above shall confirm the attendance to the employer. In the event just one of the party cannot attend this meeting under announcement time and location, the employer and employee will agree to change the meeting time and location. If both parties do not agree, the employer will decide the time and location of the meeting. Finally, step 6. The employer processes the labor disciplinary meeting according to the announced time and location.
So, are foreign employees restricted from working in any occupation?
According to the labor law in Vietnam, not on-job positions are eligible for foreign worker recruitment. Accordingly, foreign employees may only be recruited for management, execution, expertise, and technical labor positions for which Vietnamese employees are unable to meet the needs of the production and business. Therefore, labor law stipulates employer has the responsibility to explain the need to use labor before recruiting foreign employee and must have a written approval of the competent authority as discussed in the previous session. In addition, contractors, before recruiting and using foreign employees to work in Vietnam, must declare in detail the position, professional qualification, technical skill, work experience, and a working time required to use foreign employee to implement the contract and must have this proof in writing by the competent state agency. Therefore, Vietnamese law does not restrict the occupation in which foreign employees are allowed to be granted a work permit. However, there are limitations on the job position for foreign employees as set out in the regulation above.
Do foreign employees who have been granted a work permit in Vietnam have the right to own houses and other properties to meet the needs of living, studying, and working in Vietnam?
A foreign employee shall comply with the regulation on land use right and housing ownership for foreigners in Vietnam as follows. Regarding the property of the land use right, according to the law on the land 2013, foreign employees are not subject to the land allocation, land lease, recognition of land use right, or transfer of the land use right by state. Therefore, foreign employees are not allowed to transact and own the land use right in Vietnam. Regarding the property of a house under the law on the housing 2014, if foreign employees meet the condition for granting temporary resident card for foreigners entering Vietnam with a visa, foreign employees have the right to own housing in Vietnam around the following form. The first, inviting to build a house under the project in Vietnam according to the law on the housing 2014 and other relevant law. The second, purchasing, leasing, purchasing, receiving as a gift or inheriting commercial house include apartment and private house in an investment project or constructing house except in an area just ensure national defense and security under regulation of the government. In addition, foreigner employee shall comply with the regulation on the ownership of a private house or apartment in Vietnam as follows. Regarding the number of private house apartment ownership in Vietnam, foreign employees shall not have ownership of them if there exists the following assessment proportion. The first circumstance, only no more than 30% of the total number of apartments in a building. If an area having a population equivalent to the world level administrative units just has many apartments for sale and lease purchase. Foreign organization and individual can only own no more than 30% of apartment of each building and no more than 30% of the total number of apartment of the total number of such a building. The second circumstance, if the only one project had a number of the private house under 2,500 units, foreign organization or individual can only own no more than 10% of the total number of private house in such a project. The third circumstance, if the one project had a number of private house equivalent to 2,500 units, foreign organization or individual can only own no more than 250 units. The fourth circumstance, if there are the two or more projects with the total number of private house in the project less than or equal to 2,500 units, foreign organization or individual can only own no more than 10% of the number of each project. The next, if foreign employee inherited or are given a number of house just exceeds the number of the private house apartment owner mentioned above, the foreigner are only entitled to value of the excess number of such house. Also, if foreigner employee are allowed to own the housing according to agreement in transaction on a house purchase, a lease purchase, or a gift or inheritance, and do not exceed the limitation time of the 50 years from the day of the being granted the certificate. If requested, it can be extended according to the regulation of the government. The term of the house ownership must be clearly stated in the certificate. Finally, before the expiration of the house ownership under the law, foreigner employee can give either a gift or sell the house to the subject eligible to own a house in Vietnam. If there exists the time limit for owning a house, just as do not sell or give either a gift to the house, such a house will be owned by the state. Accordingly, for the employee shall satisfy the following conditions to have ownership right of the private house in Vietnam. The first, being foreigners who are allowed to enter Vietnam. The second, owning a house rather formally, just the foreigner are the permit to own as mentioned above. And the third, complying with the regulation on the owning a house for foreigner under the law of Vietnam. Regarding movable property, a foreign employee has the right to own and comply with the relevant regulation on the establishment of ownership, if any.
Thank you very much, Lawyer Thuyet, for taking the time to share with us the particularly important and necessary legal content for foreign employees and employers in Vietnam. We hope information that Lawyer Thuyet and I have discussed will provide our listener with a comprehensive overview of the legal regulation related to foreign employees in Vietnam.
Thank you, Ms. Thuy Linh, for joining me to discuss an important topic related to the labor in this episode. I hope the information I have to share has provided our listener with a comprehensive overview of the legal regulation on the use of foreigner workers in Vietnam.
Yes, thank you so much, Lawyer Thuyet. The Lawyers Talk podcast will stop here, and we thank you for your interest in listening. Goodbye, and see you again in the next podcast. If you have any questions or concerns, please leave the comment below. For more information about BLawyers Vietnam, please see our website below the Lawyers Talk podcast screen. Goodbye and see you again.